If the New York State Legislature declares that all COVID-19 deaths are accidental death benefits, does that violate the Pension Impairment Clause of the New York State Constitution? To find out, you have to read Cologne versus Teachers Retirement System, but it's 4 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Cologne versus Teachers Retirement System. The citation for this case is 2024 New York Slip Opinion 01331, published by the New York Court of Appeals on March 14th of 2024. The issue in this case is whether the modifications to the retirement system law that address the COVID-19 pandemic, do they violate the Pension Impairment Clause of the New York State Constitution? To understand and appreciate the context of this case, the background that's helpful to understand it is that Article 15 of the Retirement and Social Security Law addresses the amount of money, amount of payments that are made when a member of the New York State retirement system dies, and who gets the money. So the amount differs, and who gets the money is different, depending on whether it's an accidental death or it's a death that occurs by accident during the course of employment, or just a general death, an ordinary death. If it's an accidental death, when a member dies because of a work-related accident, the amount is an annuity equal to 50% of such person's wages earned during the member's last year of actual service, and the recipient is the statutory beneficiary. Usually, it's a spouse or a child under 25 or a dependent relative. It's a statutory list of people who are the recipients of the accidental death benefit. Alternatively, there's an ordinary death benefit. If a member dies before retirement of causes not related to a work accident, then it's equal to 1/2 of the amount of the ordinary death benefit, which would have been payable had the member's death occurred on the last day of service. And the recipient is a designated beneficiary, a person the member designates to receive that money. So it's different, but the accidental benefit is always more than the ordinary death benefit. That's important. The other thing you have to know is that New York State Constitution, Article 5, Section 7, has what's called the Pension Impairment Clause. It states, after July 1st, 1940, membership in any pension or retirement system of the state or of a civil division thereof shall be a contractual relationship, and the benefits of which shall not be diminished or impaired. So it's constitutional in nature that nothing can impair the benefits received by a pension with the state. And then the last thing you have to know is that in May of 2020, in the middle of COVID, right after COVID became a worldwide pandemic, the legislature passed a new law, Retirement and Social Security Law 607I-A3, which automatically grants accidental death benefits, which is, remember, the higher benefits, to the statutory beneficiary, which is who gets accidental death benefits, to anyone who contracted COVID-19 within 45 days of reporting to work on or after March 1st of 2020 and died of related causes. Okay. So what are the facts here? The facts are the decedent was a teacher, died in April of 2020 under COVID-19 related causes, and he had a daughter and he had a spouse, or he had a partner, not a spouse, a partner. The daughter was the statutory beneficiary who would receive, if it was an accidental death benefit, and the partner and the decedent spouse, or his partner, registered domestic partner, was his designated beneficiary. So it would receive under an ordinary death benefit. And then after he died, the legislature passed that new statute that said, if you die of COVID-19 related causes within 45 days of that date, March 1st, 2020, then it's going to be considered an accidental death benefit. The increased benefits will apply, and it will go to the statutory beneficiary, which is the daughter. So at that point, the domestic partner, the partner of the decedent, filed a complaint, filed an Article 78, said that the retirement system was violating that retirement impairment, the Pension Impairment Clause of the New York State Constitution, and was granted the application of accidental death benefits improperly, without cause. Goes to the Court of Appeals here, and on the Article 78, it says they fail. It says, listen, no beneficiary has automatic entitlement to a benefit. So even though if they hadn't passed this new law after the death of the decedent, it would have gone to the spouse because it was arguably an ordinary death, There's no right that the partner has to say, I was entitled to that. They designated it as an accidental death benefit because of the new law, and that's not arbitrary and capricious. It's based upon the entitlement to the benefit. And it's not a violation of the Pension Impairment Clause because it's actually better benefits. Accidental death benefits are always better than ordinary death benefits. And that's the case of Cologne versus Teachers Retirement System. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.